The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome to the students from Marshalltown High School. Thanks for being here this morning. We have two cases that will be submitted. Those cases are the State of Iowa versus Juanita Einfeldt, and the second case is State of Iowa versus Chad Dennis Vance. The Vance case will be submitted to the court without oral argument, and will now proceed to the arguments in the first case. Ms. Reddy.
May it please the court, counsel. I am Vidhya Reddy, and I'm here on behalf of defendant appellant Juanita Einfeldt. Ms. Einfeldt appeals her conviction for willful injury. At trial, she defended by asserting self-defense or defense of others. And on appeal, she urges that she must be afforded a new trial because the district court erred in refusing to admit certain prior and subsequent instances of aggressive conduct by the alleged victim as bearing on the question of who was the first aggressor in the incident with defendant, an essential element of defendant's claim of self-defense. It appears that the parties on appeal are in agreement that under Rule 5.404, a defendant is entitled to present character evidence of a victim to prove conduct in conformity, to show who is the first aggressor. However, the dispute centers on the form that evidence might take under Rule 5.405, specifically whether specific acts of conduct are admissible or instead character may only be proven by reputation or opinion.
Do we need to decide the issue if we can affirm on the basis of Rule 403 that the evidence of these specific prior and subsequent acts are more prejudicial than probative?
Defendant would acknowledge that Rule 403 is an independent limitation, and that we have to engage in that balancing in addition, even if it's admissible under Rule 405. However, defendant would propose that these instances do not fail 403 balancing. Specifically, I would point this court to the Massachusetts case adjudant, where the court rejected the proposition that a jury will necessarily be unduly distracted or inflamed by reference to an alleged victim's prior or subsequent specific acts of aggression.
Well, that's right, but let me ask you about what's been referred to in the briefs as the shots fired incident. I mean, I've read adjutant, and it does generally stand for the proposition, I guess, that subsequent acts that a jury may well be able to handle it. But the facts, particular facts in this case, with respect to subsequent acts, arguably are speculative at best. I mean, some shots were fired at the apartment block, and I guess there were 3 little bullet holes, but not necessarily at the apartment where the relevant apartment for your client. Casings were found. A cigarette butt was found, but the DNA, if I understand it correctly, indicated a male shooter or male smoker, actually, but the cigarette butt was found on the scene. Indeed, there was some testimony that Ms. Vinson was in the area, but all in all, we don't have a real clean. We don't have a real clean occasion. We end up with a little mini trial, and under those state of facts, maybe the prejudice substantially outweighs the probative value.
I would propose it doesn't, in light of the importance of the question of who was the initial aggressor in this case. I would propose that there is greater leeway granted for the amount that can be consumed by that. And I would point out that the offer of proof on the shots fired issue consumed 65 pages, which in the context of a trial, spanning over 1,000 pages is really not that over significant when you're talking about a defendant's ability to present proof on this specific issue.
Well, that's just the offer of proof. I mean, if the incident had been admitted, then there would have been a lot of back and forth. And as I read what the district court did, he did do, among other things, a 403 balancing, and said that we will end up with a mini trial on this other incident. It's highly disputed what happened. The police conducted an investigation, didn't charge anyone. And don't we review what the district court did under an abuse of discretion standard?
I would propose that balancing would amount to an abuse of discretion under the facts of this case. When we're talking about other uncharged criminal conduct and whether that's admissible, if it's otherwise admissible under the rules, the standard really only requires clear proof. It is not a beyond a reasonable doubt standard, and Putnam discusses the context of that clear proof standard. It can be based simply on testimony. It does not require absolute certainty that conduct was committed. And here we have witnesses that specifically said that they saw Miss Vinson peering into the windows minutes before these shots fired.
Well, the only witnesses who said that were apparently the co-defendants, the daughters of your client, or one of the daughters of your client, and the boyfriend of the daughter of your client. And the boyfriend's version was, he said that the family, that your client and her daughters weren't back at the time. He had a version of what happened, and he said it was still light out. I mean, it conflicted dramatically.
There were
with what your client's daughter was saying. So it did seem like this was kind of a sketchy scenario. It wasn't really very clear proof at all of what happened, was there?
I would say that there were distinctions in the testimony, but it was not particularly startling. He did get the time confused, which happens frequently. We see that frequently in criminal cases on both with state's witnesses and defense witnesses. And the fact that he got the time wrong is not dispositive.
He said it was light out. I mean, and
Sure,
that's a
but
big difference between 11:30 at night.
Sure, that's...
And then the officer who investigated, the person in the apartment complex who wasn't connected to your clients, who actually reported this, that person didn't see Vincent. And the officer who investigated, I think he testified in the offer of proof. Well, I called Vincent at the hospital to talk about this, and I genuinely believe she was surprised to hear the news. So, I mean, where does this all add up? The district court kind of added this all up and said, we don't need a second trial into this shooting. We've got one trial on what happened in front of Vincent's house, right?
I don't think the fact that there is conflicting testimony carries the day, and certainly people don't agree. Certainly Vincent doesn't admit that she was involved in the shots fired incident, but there's enough there. We have the testimony. It's really for the jury to decide whether to credit or discredit that testimony in light of the various things that you bring up. The police reports specifically note that it's very possible that these shots were intended for the defendant's apartment complex. There's no distinction in where it's visible, whether it's this apartment or the next apartment. They also cite both Vincent and Peitzman, her boyfriend, as potential suspects. So the fact that we don't have an undisputed factual question does not matter. There's enough there for it to go to the jury to decide whether there was involvement. It's not overly speculative, and it meets the clear proof standard to go to the jury.
What about the possibility of even like a harmless error scenario? I mean, I've watched the video of the incident where your client and one of the daughters are literally dragging Vincent on the ground and beating her, and there's no gun in sight. Nobody else who was there other than your client and the daughters claimed that the person ever even had a gun. Nobody found a gun. What about that?
Again, there was no acknowledgement, obviously, by Vincent that she had a gun, but the defendants claimed that she did, so there was a fact question on that issue. With regard to whether I would disagree that the facts are overwhelming, and certainly that little snippet shows a portion of the altercation where Vincent did not have the upper hand at that particular moment, but it captured a very small snippet.
Right, it was a small snippet, but you'd agree it doesn't look anything like self-defense. There's 3 women, and 2 of whom are dragging Vincent and really beating the heck out of her.
But their belief was that she had a weapon and that they didn't have the ability to simply walk away. So the fact that there were more of them, I don't think answers the question. It's what the type of force they believe she would be able to inflict was. And the fact that she can quickly respond with a weapon if she's not disarmed or incapacitated from doing so, I think speaks in favor of their claim of self-defense, sufficient to generate a jury question on that issue and go to the jury. And on that piece, I would note that that's the other reason that the shots fired incident has bearing, not only to connect Ms. Vincent to the use of a weapon at the earlier time and to having been the first aggressor, but also to show that her aggression continued throughout the incident and carried over to subsequent to the incident, just like in Dunson. I think the shots fired incident helps give credibility to the defendant's claim that her aggression continued despite the fact that we struck her, that we tried to disarm her. And so I think it adds credibility to...
There's no evidence at all about disarming. I mean, the 2 daughters took the stand, and they said they saw Vincent with the gun when she was inside the house. And 3 of them showed up to, pay a house call on Vincent of some kind. They saw her have the gun. Then Vincent came outside. Even they say we never saw the gun after that.
However, they didn't know where it was. And this particular gun was small enough that it could have been in the pocket. That's consistent between
Neither of them testified. Neither of the 2 daughters who took the stand said we're trying to disarm this person.
There's no
and
specific...
certainly the video doesn't look like disarming. It looks like beating up.
Sure. There's no specific testimony where anyone says specifically I was trying to disarm her of the weapon. They said they didn't know where it was. They feared that it was still on her person, and so they didn't feel safe simply walking away. And their responsive conduct was in light of those circumstances.
When we get into the competence issue, and let me share with you some of my thoughts and then get your response. But there's no question from the record that your client has a history of mental illness. And there's no question from the record that she engaged in outbursts during the trial that were inappropriate. But of course, that's not quite the issue. Many defendants have mental health issues. The real issue is one of whether she was capable of assisting the defense. And I want you to, kind of give me your best shot on why you met the necessary standard on that issue, namely that there was a reasonable belief that she could not assist the defense.
So the biggest thing, I think, is the fact that this was brought up by trial counsel, and trial counsel didn't believe that she was able to assist in her defense, and that is a pertinent factor. She also exhibited irrational and paranoid behavior during the actual course of trial. She was having, defense counsel noted that she was having trouble recalling what happened the prior day or the subsequent day.
All of this was in front of the judge. When it got out in front of the jury, whenever the jury was in, was behavior seemed to be very rational. She seemed to very much understand exactly what was going on. What she did is she would make rude interruptions, and she would say things like liar and that's not true, and make these interjections, which unfortunately a lot of defendants do. Those aren't necessarily an indicator that the defendant's not competent to stand trial. In fact, they kind of show that the defendant understands what's going on, right?
So certainly, the same the discussions, the issues about not being able to recall or understand what was going on. Those were not as clearly, they didn't make it on the record, right? Those weren't interjections that she made. But certainly trial counsel noted that those continued over the course of trial, that the stress of trial had continued. So the fact that the issues about not understanding or not remembering, the fact that those are discussed outside the presence of the jury, I don't think carries the day.
I agree that wouldn't be dispositive, but then when counsel first raised the issue, which was already, I think, the second day of trial, there had already been a day of testimony, the judge did conduct a dialogue with Ms. Einfeldt, and the judge asked Ms. Einfeldt, well, what's your defense in the case? And she explained pretty well what her defense was, namely justification in layperson's terms, and obviously not in legal terms. And the judge asked some other questions and then said, I don't think there's enough raised to warrant wholesale stoppage of the trial and a competency evaluation. I mean, what are we supposed to do there?
Well, so certainly the judge engaged in that inquiry, but in light of the entire context of the trial, the interjections throughout the trial, the fact that it was brought to the court's attention that she was having trouble understanding or processing what was going on, according to trial counsel, the fact that this continued over the course of trial, I think, defendant would propose that raised sufficient cause to suspend proceedings and engage in further inquiry by engaging in a competency evaluation. Without that evaluation, there wasn't enough for the court to conclude that it did not affect competency. Oh, I'm sorry. I realize I'm out of time. Thank you very much.
Thank you as well, counsel. Mr. Sloven.
Thank you. Thank you, Mr. Chief Justice. May it please the court. Counsel, good morning. It's good to be here. Character is not an essential element of a self-defense claim. The victim can be the most peaceful person who ever lived, and that does not disprove automatically the self-defense claim.
Of course, we said something different in Dunstan, it seems. Don't you agree?
That's right. This court has said different things about this concept in different cases.
There's a kind of a minority out there, I guess, New Mexico, Kansas, a few other states that have kind of followed what I'll loosely call, and you may think it's too loose, but the Dunstan approach under the rule, right?
That's right. There are a minority of cases that do follow that approach. The vast majority of other states, and I believe all federal circuit courts, follow the approach that this court took in Jacoby and also in Claes versus Scholl, that character is not an essential element of a self-defense claim. Therefore, Rule 5.405B prohibits the use of specific instances of conduct as evidence proving character in that regard.
Didn't we in Dunstan basically interpret our rule, and if we want to do a different interpretation, shouldn't we amend the rule?
No. I would say that what I would say is that Dunstan got the analysis wrong, ignored precedent from this court that applied the plain text of the rule correctly.
You want us to overturn Dunstan, I take it?
I think that there is no way to reconcile Dunstan with the plain text of the rule.
Your point is we either have to follow our precedent or we have to follow the rule, or we can't follow both?
I think that that's the only possible conclusion here, that Dunstan is plainly at odds with the text of the rule itself.
Now, what about the question that Justice Waterman raised, and there was some discussion with Ms. Reddy as well, that, what do we even need to reach the issue if the judge didn't abuse his discretion in the balancing that he conducted under Rule 403?
So there's not really, I don't think that it's absolutely necessary to reach that issue if we affirm on the 403 balancing. However, I think that it's very useful in this case to resolve the inherent tension in case law on this point. There's cases cited in the reply brief that apply Dunstan and take that approach. There's cases cited in the state's brief that apply Jacoby and Claes versus Scholl and take that approach. It's in judicial economy interests and consistency interests to land on a consistent interpretation and application of this
What
rule.
if we decide Dunstan is the law and send the case for a new trial? Is that in the interest of judicial economy?
Well, I think it's in the interest of judicial economy to affirm if there's harmless error. But I also think that it'd be best to avoid this situation arising in the future where counsel on both sides can point to Iowa precedent that hasn't been overruled, construing the rule in opposite, antagonistic ways. And I think the reason that happens is because the plain text of the rule so clearly contradicts Dunstan, so plainly states that character needs to be an essential element of the claim or defense before you can prove it by specific instances of conduct.
Right, but 403, the philosophy of 403 is generally relevant evidence goes to the jury, generally. But in some occasions where the evidence substantially outweighs, where the danger of unfair prejudice, et cetera, substantially outweighs, then a judge can step in. Shouldn't these evidence, if we follow Dunstan, shouldn't the jury have been entitled to at least consider? There's conflicting evidence on the shots fired. I don't think we have to go over that necessarily unless you want to, but there's evidence arguably conflicting. But isn't ordinarily that something for the jury unless it's just, kind of way out of left field? Do I state the rule correctly, or?
I think that 403 intends to give the trial judge a lot of latitude in determining how best to control the introduction and admissibility of evidence to avoid cumulative presentation of evidence, to avoid delving into mini trials on issues that are at best collateral.
I agree with all that, except the wording of the rule, which is often ignored, is that it has to substantially outweigh. The thumb is in the scales to let the evidence in generally, but you're absolutely 100% right that that the court has an opportunity to say, well, this is just too far afield. We're going to end up having 10 days of trial on shots fired and 2 days of trial on what happened. So there's no question that there's a escape valve at 403. But the general rule under 403 is that relevant evidence, the jury can kind of sort it out. And why is it that the evidence that Ms. Reddy wants to defend and get into the record, why can't a jury just figure that stuff out?
I would agree that as a general rule, our rules of evidence take a position towards a liberal sort of approach to admissibility of evidence, that anything that's arguably relevant will usually go to a jury. The limitations on that are contained in the other rules in Chapter 400 of the Rules of Evidence, that we have rules like 405 and the later rules in that chapter that erect barriers against the admission of certain classes of evidence based on a consideration and a conclusion that generally they're not relevant or have a outsized danger of being mis. And that's one of the reasons why the Jacoby cites when it construes rule, or when it adopts that approach to specific instances of conduct as evidence of character, that unless character is an essential element, there's an outsized danger of prejudice arising from the introduction of that evidence, that people sometimes, a single act doesn't establish character necessarily. People act out of character all the time, have a bad day, and it creates such a danger of falling down a rabbit hole, going into all of these specific episodes in a person's life, cumulatively just extending the duration of the trial until it's impossible to keep focus on the actual events that give rise to the charge that are the focus of the trial. And I think that is the reason why we have special rules that come into play before a 403 analysis to say, yes, our trial court judges are generally capable of making a case-by-case determination of how relevant, how probative, how prejudicial this is going to be. But this class of evidence itself, as we've determined as a general rule, is something that is going to be collateral to the issue that we're really here to try. And we don't require a case-by-case analysis in that situation. And that's what Rule 405B does.
Can I ask you some questions on the competence issue? You heard my questions of Ms. Reddy, and I think the law is clear that, you know, mental health issues alone, of course, is not adequate, and even disruptive conduct at trial is not adequate in all likelihood. But the record here is kind of interesting. Trial counsel gets up and allocutes, completely appropriate, talks about the mental health issues, that she didn't remember events of the previous day, that she had disruptive thoughts and visions, unable to articulate why she did things or what she did the previous day. And then she does take the stand, and among other things, one of the questions asked is, well, you know, will you help me, and can I read your notes, and so forth and so on. And she says, with respect to passing of notes, I think, at trial, which is a common event, no, I don't want you reading my notes. I think you're a good person. I just want to kill you. Now, that's kind of striking to me. And then she goes on to say she wants to stab her attorney in the neck with a pen, made references to contacting the FBI, somebody's poisoning the water. All right, interesting stuff. Now, maybe one can argue that we're going to let the trial continue, but then prior to prior to sentencing, there would have been an opportunity to get a competency hearing. And the standard here is, well, I mean, is there a reasonable, it is not all that high, or maybe it is high, you tell me, but I mean, it's, you know, is there a reasonable belief that there may be a competence issue? And isn't stabbing the neck with a pen, and no, I want to kill you, and you can't read my notes, and then the counsel's at least representation that there's these difficulties. Doesn't that cross the threshold? Particularly, say, if the court would have said, well, let's finish up the trial, and then we'll have a competency hearing prior to sentencing.
I'll start with the idea that the standard isn't that high, and I'd agree that the standard as articulated is there reason to doubt competency? The thing that makes that a little higher of a standard is that competency is kind of it happens before, or mental health issues themselves don't establish a competency problem. It's about ability to understand the trial proceedings, ability to understand the nature of the charges and what's happening at trial, and the ability to assist in the defense. Now, I will say that there's a lot in this transcript that gives rise to concerns that Ms. Einfeldt had some mental health issues, particularly related to, you know, outbursts and emotional management. And
She says she wants to kill her lawyer. That's kind of a problem.
Definitely some distrust there. But she clearly understands the nature of the charge. She's definitely saying all of her outbursts are calculated towards showing or arguing that she and her daughters were justified in what she did. Throughout the, you know, after that initial discussion and that distrust, she is working with her attorney throughout the trial. There's even moments where the court has to instruct her to, you know, speak more quietly with her attorney during witnesses' testimony in order so that the court reporter can get a transcript and hear what's being said. She corrects him during oral argument when he uses one daughter's name instead of the other. She tries to help him. She tries to guide him towards admitting things that she thinks are relevant to dispute Vincent's character during the offer of proof on Ms. Cicchione's testimony. Throughout the trial, there are all these examples of, you know, yes, she doesn't really trust the system. She doesn't really trust her appointed attorney. All of that is true on some level, but she is able to assist in the defense. She's able to understand what's happening. And there's no evidence. Now, if there's a claim that something happened, that there was a communication breakdown between her and her attorney, that's something different. I don't really see that emerging out of this record.
Well, counsel, if she doesn't trust her lawyer to even read what she's writing, doesn't that disrupt the relationship between she and her counsel? I mean, you've talked about the three factors that we're considering here. Are they all of equal import, or does the ability to assist in her counsel in the defense maybe deserve some elevation over the other two?
I would disagree with that, and I'd say it's
I'm
actually...
asking you if it does. I'm not saying it does.
Oh, I would say it doesn't. I think that the first two elements of competency are actually more important because they reflect the cognitive and ability to process what's happening at trial, the understanding there. Now, if there's some distrust and some personality conflicts, that can affect the attorney-client relationship. I think that by the end of this little inquiry and as the trial goes on, I think that calms down and she's able to, I think the record shows that they are collaborating and cooperating as the trial goes on.
The biggest piece isn't that originally she wants to take the stand, and at the end of the trial she says, I'm going to take my advice and not take the stand, which, as an armchair lawyer, former criminal defense lawyer in part, I would say that was a pretty good decision on her part.
Right, possibly the biggest strategic decision in front of her, and she makes it on, she reconsiders her original decision and also reconsiders it after seeing one of her daughters be cross-examined.
What's the rationale for not having an examination prior to sentencing?
I think the rationale is that there just was not a doubt appearing to the trial court judge after being in the courtroom and witnessing and all of the pretrial proceedings as well and watching the videos and being in the courtroom the whole time with Ms. Einfeldt. There were mental health concerns. There was not a doubt appearing to the trial court judge about her competency, about her ability to understand what was happening, about her ability to...
Wow. I mean, she has elements of lucidity, it seems, but at least there's some. She states she doesn't remember half the events that happened the previous day. I mean, maybe she does, maybe she doesn't. I understand that, but she states that she doesn't remember this stuff, and she states that she wants to kill her lawyer, and she states that there's poisonous waters. She states the FBI is on the scene. She probably made the right judgment not to take the stand. I suspect that's true. But does this raise a question? Is there a reasonable possibility that she's not really able to assist in her defense if in the lawyer's conference room they're talking about poisoning water and FBI and I want to kill you and stab you with a pen?
And thank you. So I think that it is not uncommon to find delusional thinking. The existence of those delusions, I think, is on some level, on a mental health level, cause for concern. But it's collateral to the issue of competency. Whether or not she knew somebody in the FBI or had any cause for any of those beliefs, whether or not those are fully delusions, of whether she understood what was happening in that room, the conversations that they were having with the trial court judge, the conversations she was having with her lawyer, the evidence being presented. I think that the trial court judge was right to say, I have some concerns about her mental health generally, but no concerns about her competence regarding the ability to know that she's on trial for this offense, that she's claiming self-defense, and to assist however she's able to in presenting that defense at trial. I don't think there was a competency issue here. Thank you.
Mr. Sloven, thank you as well. Rebuttal?
Thank you. Starting with the competency issue, I point out and emphasize, as was discussed a bit in just the prior discussion, the standard is whether there was a substantial question of competency. It is not whether the evidence in the existing record definitively establishes that this defendant was not competent. The question is whether there was enough there that the court should have ordered a competency evaluation. And defendant's position is that there was enough there to suspend proceedings and order a competency during trial, or alternatively to do so prior to entering judgment and conviction.
But if you had after she's already been found guilty and you had the competency evaluation there, you wouldn't throw out the verdict, would you?
I think you would. Because
a precedent for that?
Well, I think the issue is the competency evaluation, because the competency issues arise during the course of trial, and really the only reason to defer it until after trial is is judicial economy concerns, right, that we're already into trial. But the competency evaluation that's done even subsequent to trial would have to evaluate her competency at the time of trial. So it's a backward-looking evaluation in addition to whether she's competent at the time of sentencing. And so I think that's the type of analysis that would have to be undertaken. And based on that competency evaluation, if it came back that she was not competent, I think her conviction would have to be overturned, and she would have to get a new trial once she obtained competency.
I guess I have a question, again, just following up on Justice Mansfield's question. What authority is there for that? I guess I am not really aware of any authority that would allow you, after the conviction has already been there, to then do a competency evaluation, and for what purpose? To look back and decide, oh, well, I guess I made a mistake? I don't understand the concept, and so if you have some authority that I would like to know about it that would provide for a competency evaluation before sentencing.
Well, in terms of authority for providing competency evaluation before sentencing, certainly that's in Rule 2.23 and under Chapter 812 generally. In terms of specific authority where there was a post-trial competency evaluation to evaluate her competency at an earlier point, there's no specific authority from where that was done in the district court. Certainly that happens when a defendant appeals up and says, hey, the district court got it wrong, they should have granted a competency evaluation at that time. And so there's some discussion, I think, in Myers, in the Iowa 1990 case, and possibly also in Rode, which is the Court of Appeals case from 93, both cited in the briefs, where, because certainly that happens all the time, where we say the court got it wrong, they should have ordered a competency evaluation, and so on appeal, we send it back and say, do the evaluation, and if they're not competent, if they weren't competent at the time of trial, then they get a new trial. So I think this is really just an extension of that. I think that's within the authority of the court to do. The point ultimately is...
Those are the authorities then that said after the fact that the district court should have ordered a competency hearing and then remanded it back to do a competency hearing?
Correct. And I believe in Myers there was a discussion about the difficulty of making that post facto determination when there's that extended period of time, which maybe wouldn't have been there to quite the same extent if it was done after or just prior to sentencing.
What about the occasions where she seems to have a degree of lucidity? There are occasions in the record where, I mean, she is at least kind of following what's going on. I mean, it's not like she's, her eyes are glassed over and she has no idea what's going on. I mean, at least there are substantial parts of the record where that's not what's going on. She seems connected. She generally knows what her defense is and so forth. How do we do the analysis when, if on some occasions she seems to be connected, and then on other occasions, particularly at the, before the court, when she says, "I'm not going to let you read my notes. I want to kill you." The record's kind of mixed, it seems to me. So how do we approach that?
It is mixed, but again, the question is just whether a substantial question was presented as to competency. And in light of the intensity and the nature of the times when there are causes for concern, the extent to which those pervade the trial record over the course of the entire trial. And I think, again, most compelling that defense counsel brought this up to the court, which is not typical, does not happen very frequently. I think those factors are enough to raise that substantial question. And the fact that it comes and goes, it's the fact that at points we see what appears to maybe be a rational being, I don't think negates that. There was enough there that a competency evaluation was required in order to determine whether she was in fact competent for trial. With that, if there are no more questions, I ask this court to grant defendant a new trial. Thank you.
Ms. Reddy, thank you as well. Case of State of Iowa versus Juanita Einfeldt is now then submitted to the court, and the bailiff may adjourn. Thank you again to the students for coming.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.